Good morning and welcome to today's oversight hearing on clemency in the Office of the Pardon Attorney. I would like to remind members that we have established an email address and distribution list that circulate exhibits, motions, or other written materials that members might want to offer as part of our hearing today. If you would like to submit materials, please send them to the email address that has previously been distributed to your offices, and we'll circulate the materials to members and staff as quickly as we can. I would also ask all members, both those in person and those attending remotely, to please mute your microphones when you're not speaking. This will help prevent feedback and other technical issues. You may unmute yourself anytime you seek recognition. Due to the size of our panels today, I will strictly enforce the 5-minute rule. I now recognize myself for an opening statement. During today's hearing, the subcommittee will examine executive clemency and explore solutions to improve the process of evaluating clemency petitions and making recommendations to the president. Although the authority to grant clemency vests solely with the president, the Office of the Pardon Attorney, a unit within the Department of Justice that is congressionally created and funded, aids the president in the exercise of the clemency power through an administrative process established by regulations that develop somewhat haphazardly. The rules, which were first promulgated by President McKinley in 1898, provide that clemency petitions are to be directed to DOJ and require the Attorney General to make a recommendation to the president on the merits of those requests. The relatively simple process for evaluating petitions and making recommendations evolved during the 1970s and 1980s, and now includes 7 levels of review, the first 4 of which reside within the DOJ. The Office of the Pardon Attorney, under the direction of the Deputy Attorney General, is responsible for processing petitions for executive clemency, reviewing case materials, vetting petitioners, and providing recommendations to the president. It is where the clemency process begins and ends for some petitions. Understanding the central importance of the Office of Pardon Attorney to a discussion about clemency and our committee's oversight over both the Department of Justice and the Office of the Pardon Attorney, I thought it best to have the Pardon Attorney participate in our conversation today. It is unfortunate that we were unable to reach an agreement with the Department of Justice to have the Pardon Attorney here to discuss how we can increase efficiency and account for and reduce bias in the clemency process, because as the Supreme Court has noted, executive clemency serves a vital role in the criminal justice system. We know so many families that are struggling with loved ones who deserve to have that consideration. And so I expect to have the Pardon Attorney here in the very near future, singly or for a briefing before this committee, singly in a hearing or at a briefing for this committee. It is imperative that all elements of this process come before this committee for our appropriate oversight. The framers of the Constitution understood that the criminal justice system needed a check that would guard against unjust or excessive punishments. Clemency can be a useful tool to right the wrongs of the failed war on many aspects of the criminal justice system and overcome misguided policies that led to mass incarceration by unburdening those who languish in prison or who suffer from the collateral consequences of their convictions. Certainly some of those were in the times of the excessive penalties for those who had basic possession in terms of drug cases, minimal drug cases with decades of sentencing and incarceration. If that is to be the case, Congress should encourage the president to use executive clemency and power routinely by fixing an apparently broken system and providing the president with the support he needs. That was done just a few weeks ago by President Biden. Clemency decisions should be made objectively, systematically, and with transparency. Yet we know that the modern clemency process cycles between periods of inaction and controversy, but there have been a few instances in the exercise of executive clemency that varied from what we have become accustomed and from what we must learn. In 1974, President Ford establishes the temporary Presidential Clemency Board and identified more than 13,000 clemency recipients following the Vietnam War. President Ford and Carter granted clemency the hundreds of thousands of men who evaded the draft. Then in 2014, DOJ, at the behest of former President Barack Obama, announced the Clemency Initiative, which focused on nonviolent drug offenders, so many that were incarcerated for decades. Despite initial problems in planning, implementation, and management through the initiative, DOJ substantially increased the number of recommendations to the White House, resulting in 1,696 individuals receiving clemency, appropriately so. Significant changes, which we would make note of, were made in the final year of the initiative that enabled DOJ to meet its goal of making recommendations to the White House on over 13,000 petitions. For example, DOJ temporarily increased staffing at the Office of Pardon Attorney to meet the demands of the initiative. The Office of the Pardon Attorney prioritized the review of petitions from individuals who were strong candidates for clemency, and DOJ streamlined the review process. Taking lessons from Obama's Clemency Initiative, we should consider whether there are incentives or measures Congress can implement to permanently streamline and shorten the timing of the review process to avoid the dilemma President Biden currently faces. I would have liked to ask the pardon attorney how she plans to tackle the backlog of 15,000 clemency petitions President Biden inherited over taking office in an efficient and just manner, or how Congress can help. We must also consider the longstanding criticism that there is an inherent conflict in the review process when it begins with DOJ if the president is to make better use of the clemency power. Since the pardon attorney is not here, I hope our witnesses can offer sensible solutions and proposals for reform of the clemency process, as well as ways in which clemency can be used as the framers of the Constitution expected. I thank each of our witnesses for their participation. I look forward to a robust discussion. Without objection, I will submit into the record the following documents: a New York Times guest essay written by Rachel E. Barkov, Marc Osler, entitled "We Know How to Fix the Clemency Process, So Why Don't We?" dated July 13, 2021. An entry from the Federal Sentencing Reporter, volume 34, by Marc Osler, entitled "The Role of the Clemency in Criminal Justice Reform." Let me also thank my colleague and Vice Chair, Congresswoman Cori Bush, for her interest in this hearing and her invaluable help as we proceeded to have this hearing and as we proceed further to secure the pardon attorney. And might I also mention with deepest sympathy to the families of those lost in Buffalo, New York, and those lost in the accusation of guns and hatred. But as we proceed in this hearing, I hope that we will find as many facts as necessary to improve this process and to improve the criminal justice system. I now recognize the gentleman from Arizona, Mr. Biggs, for his opening statement. Mr. Biggs, you are recognized.
Thank you, Madam Chair, and I appreciate you holding this hearing today. Today's hearing is entitled Oversight Hearing on Clemency in the Office of the Pardon Attorney. It is interesting, and I appreciate you reporting that you attempted to bring the new pardon attorney to our hearing today. The new pardon attorney is Elizabeth G. Oyer. She served 10 years as a federal public defender, and I look forward to hearing her in the future about the pardon attorney's position and her thoughts on the proposals that we're going to hear today. This hearing is actually just another in a series of hearings that furthers the agenda of my friends on the other side of the aisle with their intention of totally reforming the justice system, and with some of their initiatives actually putting the public safety at risk. The first in the series was a hearing on controlled substances, federal policies, and enforcement. In that hearing, while arguing for drastic reform of our drug laws, one of the majority's witnesses likened our nation's drug laws to Jim Crow laws. Then the subcommittee held a hearing entitled "From Miranda to Gideon," a call for pretrial reform. My colleagues on this subcommittee have some interesting, actually dangerous ideas about pretrial criminal justice reform, and one of them introduced the No Money Bail Act of 2021. This bill would eliminate bail in the federal system and withhold federal grant money from states that don't eliminate their bail. We've seen time and time again all over this country the disastrous and deadly consequences of eliminating bail. At that hearing, we heard from a grieving mother who lost her son because the state of New Jersey implemented bail reform that allowed a convicted felon back out onto the street. Next, we had another hearing on undoing the damage of the war on drugs, a renewed call for sentencing reform. This was another hearing where the majority's witnesses called for decriminalizing drug possession for all drugs, and no matter how much drugs that they had in their possession. And that brings us to today's hearing on clemency. In my reading of Article 2, Section 2 is that the president has broad authority to grant reprieves and pardons for offenses. The president ultimately makes the decision on how to reprieve or provide clemency. And thus, the president actually has the opportunity, and quite frankly, I think has the obligation to create the rubric for granting clemency and the standards that the president's going to look at before granting reprieves, pardons, and commutations or clemency. So, with that in mind, I don't think anybody in the room doubts the president has constitutional authority in this area, nor do we think that the president's authority to commute sentencing of drug offenders is outside of the scope of the president's authority. And so, because the Constitution seems to vest that authority with the president, the rubric seems to also lie with the president. Just because the president may commute such sentences does not necessarily mean that the president should take action at all. While such commutations do not raise constitutional concerns, they certainly can raise public safety concerns. During the last 2 years, the United States has seen a spike in violent crime. In 2020, the United States tallied more than 20,000 murders, the highest total since 1995, and 4,000 more than in 2019. And FBI data preliminarily for 2020 points to a 25% surge in murders. This would be the largest single-year increase since the agency began publishing uniform data in 1960. Last year, in America, there were more than 105,000 drug overdoses. That follows a record in 2020 with more than 91,000 overdose deaths. Now may not be the time, despite what the Biden administration and any of my colleagues believe, to release drug traffickers and dealers back into our communities and neighborhoods. Just last month, the Biden administration commuted the sentences of 75 drug traffickers and dealers. President Obama similarly commuted the sentence of 1,715 drug offenders. And some of those granted clemency by President Obama went on to reoffend not long after they were released, many back to selling and trafficking drugs. At a time when overdose deaths and violent crime is surging, this subcommittee should probably not look to ways to let more drug dealers and traffickers out of prison early. And more importantly, in some respects, is the philosophy of this, and that is that it is the president's prerogative. That means it's the president who either designs, accepts the current rubric, or implements a new rubric in determining early releases, commutations, pardons, reprieves. We can comment on it, is my position, but I don't think we can legislatively, at least in a constitutional manner, impose upon the president our will on how the president determines to grant reprieves and pardons. That is plenary power exclusively reserved to the President of the United States. Madam Chair, with that, I'll yield back.
Thank you. The chair now recognizes the chairman of the full committee, the gentleman from New York, Mr. Nadler, for his opening statement. Good morning.
Thank you. I thank Chairwoman Jackson Lee for holding this important oversight hearing on executive clemency and the Office of the Pardon Attorney. I hope that today's discussion provides us with proposals that will enable President Biden and his successors to apply the power of executive clemency as the framers intended, as a tool necessary to the fair administration of justice that tempers justice with mercy. Over the past several decades, Republicans and Democrats have failed to employ this power, which rests solely in the president, to help remedy injustice as the framers first conceived. After decades of draconian mandatory sentencing policies, far too many nonviolent federal offenders, disproportionately people of color, remain in prison serving what we know now are unnecessarily harsh sentences. Some of these prisoners are elderly and suffering from chronic illnesses and have served their debt to society many times over. Many others face hardships when seeking re-entry into their communities after completing their sentences because of the collateral consequences of their convictions. Clemency is the only remaining relief for many of these people. Yet thousands of clemency petitions are currently pending due to the more than 15,000 petitions left by the previous administration for President Biden to consider. The tremendous responsibility of reviewing these petitions and making recommendations to the President has been customarily delegated to the Office of the Pardon Attorney, an agency within the Department of Justice. This subcommittee has both the authority and the obligation to evaluate the efficacy of this office and to improve upon its ability to support a vital authority of the executive. I know that many of our witnesses today agree that the current clemency process requires immediate reform. Some may even argue that the process should be removed from the Department of Justice altogether because of the inherent conflict of interest posed by placing the authority to review petitions for clemency within the same department that prosecuted each prisoner. In recent years, much of this committee's consideration of clemency was centered around abuse of the pardon power by presidents of both parties in individual cases. I appreciate the opportunity today instead to focus on clear-minded systemic reforms that will increase the rate and diversity of clemency grants, paying special attention to the plight of incarcerated women and minorities who have borne the brunt of the so-called war on drugs. I commend President Biden for doing what many previous presidents have not, that is, issuing grants of clemency earlier in his term and not just before his presidency ends. Last month, he used criteria similar to those used by President Obama to issue more than 1,700 grants of clemency, primarily to nonviolent drug offenders who would have received a lower sentence if they were charged with the same offense today. Recalling our recent discussions surrounding the exercise of compassionate release and implementation of the First Step Act, we know that there are thousands more remaining in prison or who are now released in home confinement with similar stories. I hope that our witnesses today will discuss how Congress can help the Office of the Pardon Attorney and the President reach more of these individuals and provide relief that will allow them the ability to return to their communities from home confinement without risking return to prison. Although Congress has little authority over the President's exercise of the clemency power, we can enact measures that will pave the way for more clemency grants. We can also assist in reforming the processes we do have control over to ensure that petitions are treated fairly and timely and as a routine mechanism of the criminal justice system. I would like to thank the witnesses for appearing today. I look forward to hearing their testimony, and I yield back the balance of my time.
I thank the gentleman.
Madam Chair, you are frozen. We got a technical issue going on, Madam Chair.
Let me try. Am I back?
Yes.
Am I back?
Yes, you are.
All right, is Mr. Jordan present?
No.
Yes, is Mr. Jordan present?
No, he is not present, Madam Chair.
No. Thank you. When he comes, Ranking
We'll take her off, and then let's go to the introduction, and I'll text her and tell her to log back in.
Yeah.
It is now my pleasure to introduce the witness for the first panel. The Honorable Ayanna Pressley was elected to represent.
Well, she reps something.
Can you hear me?
Yes.
Can you hear me?
Yes.
Let me quickly. All right. The next witness, the Honorable Ayanna Pressley, was elected to represent Massachusetts 7th Congressional District in the House of Representatives on November 6, 2018. House of Massachusetts. She was also the first woman of color to serve in the 100-year history of the Boston City Council. She is an advocate and a fighter for informed and robust policies and an advocate for positive change for the most vulnerable and an important legislator We're delighted to have her here 5 minutes, and we welcome you as our distinguished witness. Thank you for your participation. Please, accordingly, I ask that you summarize your testimony in 5 minutes to help you stay within the time frame. There is a timing light on your table and on your screen. When the light switches from green to yellow, you have 1 minute to conclude your testimony. When the light turns red, it signals that your 5 minutes.
Should I go? Okay. All right, good morning.
Yes, yes.
All right, thank you. Good morning, Chairwoman Jackson.
Good morning.
Lee, Ranking Member Biggs, and Chairman Nadler, and members of the Subcommittee on Crime, Terrorism, and Homeland Security. Thank you for the invitation to testify on my legislation, the Fair and Independent Experts in Clemency Act, also known as the Fixed Clemency Act. In the U.S., there are approximately 2 million people incarcerated in the criminal legal system, and over 200,000 in federal custody, disproportionately Black, Latino, Indigenous, disabled, and LGBTQ+. Our nation has the highest incarceration rate of any country in the world. This should ring alarm bells for every lawmaker because it impacts mass incarceration each and every one of our districts. And it should stoke the moral outrage of everyone who calls this nation home, as this is a shameful legacy. People locked in cages throughout this nation, real people, their families and friends are serving their sentences alongside them. I know this all too well, growing up with an incarcerated parent. I can only imagine how different my own childhood would have been if my father was able to get the medical help and treatment he desperately needed and deserved. Instead, his opioid addiction, which today would be treated as a public health issue, was criminalized. And his addiction robbed me of his physical presence during my most formative years. Today, my father, Martin Terrell, like millions of Black men and women, is a survivor of mass incarceration. He's attained multiple degrees, gone on to be a college professor, and published author. Nonetheless, his presence having been robbed of his presence during my formative years, it has been an ongoing, healing process for myself and our family. My story is hardly an anomaly. Across the country, more than 5 million children have experienced the incarceration of a parent. As policymakers, we must reject this unjust status quo and disrupt the cycle and legacy in this country of treating trauma with more trauma. We need to end the crisis of mass incarceration, and fixing our clemency process is a central part of the solution. That is why I'm proud to have introduced the Fixed Clemency Act with 2 distinguished members of the Judiciary Committee, Representatives Bush and Jeffries. My legislation would transform how clemency works by replacing the redundant and biased Department of Justice process with a new and independent U.S. Clemency Board. The board would be composed of experts in fields like behavioral health and rehabilitation appointed by the president. There would also be a seat at the table for a person who is formerly incarcerated, because I believe the people closest to the pain should be the closest to the power, driving and informing the policy making. Currently, applications for clemency are under the full control of staff in the Department of Justice and must undergo repeated scrutiny with duplicative layers of bureaucratic review. Experts have warned that this structure creates a prosecutorial bias against each applicant, and at any point in this process, one lone staffer can unilaterally prevent an application from moving forward. The Fixed Clemency Act makes clear that prosecutors and people who run prisons should not have outsized influence when it comes to evaluating clemency applicants. With my bill, the newly created board would be transparent and independent. All recommendations by the board would be transmitted directly to the president and included in an annual report to Congress. With more than 17,000 clemency applications pending for years before the DOJ, we must pass the Fixed Clemency Act. That's over 17,000 people, and their lives hang in the balance. I'm proud that my bill was drafted in close partnership with lawyers, constitutional scholars, advocates from across the political spectrum, and those who understand clemency best, people who are formerly incarcerated. People like Danielle Metz, who is a recipient of clemency herself. She was punished with 3 consecutive life sentences and an additional 20 years in federal prison for non-violent drug offenses. She served more than 2 decades in prison away from family and her children before her sentence was finally commuted. I'm grateful for her partnership in this legislation. Congress has the power to legislate a just and equitable clemency process by passing my legislation to create an independent board. I applaud President Biden for granting 78 commutations and pardons last month. It establishes a historic precedent and will help set the individuals, their families, and communities on a pathway to healing. We must continue this historic momentum. To truly confront the backlog of over 17,000 applications and prevent it from ever occurring again, there must be structural change. More than 150 years ago, Congress created the current clemency process, and now it is time for Congress to fix it. Thank you.
Let me thank you for very insightful testimony. We were very pleased to have you before our committee and very pleased that you accepted. And so thank you very much. At this time, we'll move to the second panel.
What?
Just say that we're saying a recess. I think she froze again.
This concludes the first panel of today's hearing. I would like to thank Representative Presley for participating in this hearing. We will now take a short recess to set up our second panel of witnesses. We're recessed for 5 minutes. Did you hear me? The subcommittee will reconvene to hear the testimony of our second panel. I will now introduce our second panel of witnesses. Professor Marc Osler is a Robert and Marion Short Professor of Law at the University of St. Thomas School of Law. He is a former federal prosecutor and author whose writings on clemency, sentencing, and narcotics policy have appeared in the New York Times, the Washington Post, and the Atlantic, and many law journals, including at Harvard, Stanford, the University of Chicago, and Georgetown. Professor Osler is a graduate of the College of William and Mary and Yale Law School. Mr. D. Michael Hurst Jr. is a partner with Phelps Dunbar, LLP. He was the U.S. Attorney for the Southern District of Mississippi from 2017 to 2021, and previously served as Legislative Director and Counsel to Congressman Chip Pickering and as Counsel for the Constitution Subcommittee of the House Judiciary Committee, and that was Congressman Chip Pickering. He graduated from Millsap College and the George Washington University Law School. Professor Rachel Barkow is Vice Dean, and Charles Siligonson, Professor of Law at NYU School of Law. She serves as the Faculty Director of the Zimroff Center and the Administration of Criminal Law at NYU. From 2013 to 2019, she served as a member of the United States Sentencing Commission. Professor Barkow graduated from Northwestern University and Harvard Law School. She served as a law clerk to Judge Lawrence N. Silberman on the DC Circuit and Judge Antonio Scalia on the US Supreme Court. The Honorable Morris J. Murray has been the prosecuting attorney for Defiance County, Ohio, since his election in 2009. He also serves as legal counsel for the Board of County Commissioners, county officials, and several other public boards and agencies. Attorney Murray is a graduate of the University of Dayton and the University of Dayton School of Law. Nkechi Tafaya is president and CEO of the Tafaya Group LLC, founder and convener of the Justice Roundtable, and serves as senior fellow for the Columbia University Center for Justice. She serves as advocacy director for criminal justice at the Open Society Foundation. She has also served as legislative and policy counsel for the ACLU, the Women's Legal Defense Fund, director of Howard University School of Law's Equal Justice Program, and staff attorney for the National Prison Project. She graduated from Howard University and George Washington University Law School. Ms. Andrea James is the founder and executive director of the National Council for Incarcerated and Formerly Incarcerated Women and Girls, and the founder of Families for Justice as Healing. She is a former criminal defense attorney, formerly incarcerated woman, and author. Ms. James is a 2015 Soros Justice Fellow and a recipient of the 2016 Robert F. Kennedy Human Rights Award. Mr. Jason Hernandez was granted clemency by President Barack Obama on December 19, 2013. Upon his release, he earned his high school diploma and founded several nonprofit organizations, including At Last, which empowers Latino students to become leaders in their schools and communities and helps them pursue careers where Latinos are underrepresented. Mr. Hernandez received fellowships from the Open Society Foundations and Open Philanthropy via Latino Justice, and serves as a consultant to the ACLU's redemption campaign, Embracing Clemency. Mr. William R. Underwood received compassionate relief after 33 years of incarceration. Mr. Underwood is currently a senior fellow with the Sentencing Project's campaign to end life imprisonment. He is also a consultant, public speaker, advisor, and advocate at the Underwood Legacy Fund, where he advocates for the rights of songwriters, producers, composers, lyrics, and music publishers. We welcome all our distinguished witnesses. We thank them for their participation. I'll begin by swearing in our witnesses. I ask our witnesses testifying in person to rise and ask our witnesses testifying remotely to turn on your audio and make sure that I can see your face and your raised hand while I administer the oath. Witnesses are unmuted. Do you swear or affirm under penalty of perjury that the testimony you're about to give is true and correct to the best of your knowledge, information, and belief, so help you God?
I do.
Let the record show the witnesses answered in the affirmative. Thank you, and please be seated. Please note that your written testimony will be entered into the record in its entirety. Accordingly, I ask that you summarize your testimony in 5 minutes. To help you stay within that time frame, there is a timing light on your table and on your screen. When the light switches from green to yellow, you have 1 minute to conclude your testimony. When the light turns red, it signals that you are now welcome. Mr. Osler, you may give your statement.
Thank you, Madam Chair, Mr. Ranking Member. Thank you for this opportunity to be heard this morning on this important subject. I'm going to use my time to describe the broken system that we use to evaluate clemency petitions. The pardon attorney is a part of this broken process, but only a part, and probably not the most important part. I've prepared a chart of the current process. It's also included in my written testimony as well. If you look at the chart that's here to my left, you'll see that there is a green box at the bottom left-hand corner. And what that represents is this is a commutation petition, someone in prison, usually preparing the petition themselves. They're going to fill out the form, they're going to send it in to the pardon attorney staff that's going to do an analysis of it and come up with an opinion. Now, they're going to reach out to the local U.S. Attorney's Office and get their opinion, which will be given considerable weight going up the chain. Once the pardon attorney staff has their report, it goes to the pardon attorney, who's going to make an independent evaluation. Now, from there, it doesn't go to the president. Instead, it goes to a staff member at the Deputy Attorney General's office, and that's the middle blue box in the rank of 3 there. And that staff member is going to make a recommendation. And then that goes to the Deputy Attorney General. From there, it goes to a staff member at the White House counsel's office. And after that, it goes to the White House counsel. And only after that, after 7 sequential steps, does it go to the president. This is a terrible process. Whether you think a lot of clemency should be granted or only just a few, this is a bad process for getting to the right ones. And Mr. Ranking Member, I'd note that in terms of the president having input and having a rubric that would be controlling, having so much separation of bureaucracy between the president and the people who are doing the evaluation doesn't help that at all. It's undisputed that no business, at least no decent business, no successful business, would make decisions in a process like this. Now, this process was not designed in any coherent way. It grew up organically over time. For example, the Attorney General originally met with the President to advise him directly about these petitions. But then that was delegated to the Deputy Attorney General, who then had a staff member intercede in between the pardon attorney and the DAG. And then the White House counsel got involved. And so over time, as bureaucracy does, it grew up. and it just doesn't work. A couple of the problems here. One is the sequential nature of the decisions. And this combines with another problem, which is negative decision bias. No one gets in trouble for saying no. All the risk is in saying yes. And so if we think about this as a pipe with 7 valves, and they all have to be opened for any petition, even the best petition, to get to the end, and they're spring-loaded shut. No wonder this process doesn't work. Another problem is that you have 2 key positions here that are people who are generalists, who are really busy. And one of them is the Deputy Attorney General, who has operating control of much of the Department of Justice. And what has happened with this process isn't just that the Deputy Attorney General oversees the process, but personally vets each petition. And when you have 17,000, 18,000 petitions, that's just not going to work. And frankly, it hasn't. The White House counsel as well, of course, has many jobs to do, and this is just one of them. So what to do? Well, we just heard about the well-named Fixed Clemency Act, and that would eliminate much of this bureaucracy. And yes, bring the process closer to the president so that the president's will about clemency can be respected in a more direct way. I want to close by telling you why I care so much about this. This has become my life's work. In part, it's because I hate bureaucracy, but it's also a matter of faith. My work has integrity because a core value of my Christian faith, mercy, is also found in the constitutional pardon power. It's rare to find a faith imperative that so clearly is also a constitutional imperative. And even though my own perspective is as a Christian, I know that mercy is a core value of Judaism, of Islam, and nearly every moral system that is either religious or secular. Americans love freedom, and we believe in mercy. We just need to build a machine that reliably can provide us with just that. Thank you.
Thank you very much, Professor Osler, for your testimony. Thank you again. Mr. Phelps, you're now recognized for 5 minutes.
Thank you, Madam Chairwoman, ranking members, member of the subcommittee. My name is Mike Hurst. I'm a partner in the Jackson, Mississippi office of Phelps Dunbar. And before that, I served as a United States Attorney for the Southern District of Mississippi. I appreciate the invitation to be here today to testify about the clemency process and the DOJ's Office of the Pardon Attorney. Before joining Phelps in January of 2021, not only did I serve as United States Attorney, but I also had stints as an Assistant United States Attorney, a nonprofit lawyer, a private practitioner here in Washington, D.C., a congressional staffer, and as the Madam Chairwoman said, counsel to the Constitution Subcommittee, which Mr. Nadler was the ranking member at the time. I'm here today, though, to give my perspective on clemency and the Office of the Pardon Attorney, specifically in my experience as a former chief federal law enforcement officer and a former federal prosecutor on the front lines, and also now as a criminal defense attorney. Let me just be clear, the views I'm expressing today are my own. They do not represent my firm, my clients, or anyone else. First, during my tenure as United States Attorney, I was asked by the Office of the Pardon Attorney on several occasions to give my thoughts on petitions for clemency of defendants who had been prosecuted in our office. I believe as a policy matter that asking the prosecutor's opinion of a petition is not only appropriate, but it's vitally important, as no one knows these defendants and the circumstances surrounding their criminal cases better than the prosecutor. As U.S. Attorney, and before that as an Assistant U.S. Attorney, my role was not to lock someone up or to keep someone locked up. Rather, our role as federal prosecutors was to ensure that justice was done. For brevity's sake, I will summarize or paraphrase Justice Sutherland's 1935 language in Berger v. United States, which says, the United States Attorney's interest in a criminal prosecution is not that it shall win a case, but that justice shall be done. As such, he is in a peculiar and very definite sense the servant of the law, the twofold aim of which is that guilt shall not escape, nor innocence suffer. It is as much his duty to refrain from improper methods calculated to produce a wrongful conviction as it is to use every legitimate means to bring about a just one. Thus, in my role as U.S. Attorney, I recommended approval of some petitions and disapproval for others, always with a mindset towards ensuring that justice was done. DOJ's policies that clemency petitions should only be granted in extraordinary circumstances and clemency should be exercised rarely are the correct judicious approaches to this issue. These approaches ensure that justice is done. Second, the process for clemency entrusted to the pardon attorney is and has been working and does not need revising or wholesale revamping. The attorneys in the Office of the Pardon Attorney, in my experience, have always been professional, fair, methodical, and deliberate. Exactly what we all should want and expect of those reviewing petitions of people who want out of prison. I never experienced any type of bias or skewed judgment from the pardon attorney, either for or against petitions, nor did I ever hear or witness any type of pressure on the pardon attorney from prosecutors or others within the Department of Justice. The multiple possible veto points throughout the process is not a flaw, but rather a positive part of the system. As those checks and balances, these multiple points of review are reevaluating someone who has been investigated, prosecuted, and convicted for violating our criminal laws. And we should make damn sure they are not a threat to society and run all the traps necessary to ensure that before releasing them back to the public. Finally, there are some advocating for creating a new independent federal government agency to address these perceived issues. But I believe President Ronald Reagan had it right when he said the closest thing to eternal life on earth is a government program. The last thing we need is another government agency or program. And even if Congress were successful in establishing this new U.S. Clemency Board, as the ranking member has pointed out, the president has almost unlimited authority to grant clemency. So there would be no authority requiring the president to use, rely upon, or defer to this new government agency. In conclusion, the clemency process today is not perfect, but it works relatively well considering the resources of the Office of the Pardon Attorney and the professionalism that office exhibits. Clemency should be granted only in rare, extraordinary circumstances, and petitions for clemency should continue to have many levels of review before they reach the president's desk. If a president wants to expedite the process, he has more than enough authority to do so.
Gentlemen, time expired. You can finish.
Yes, madam. Those who want to simply release more criminals, defund our police, and not enforce our criminal laws will only further increase already rising crime throughout America and make America less safe. Thank you.
Gentleman's time has expired. Let me, for the record, make sure that Mr. Hurst's full name is complete. It is D. Michael Hurst, who's the witness that we just heard. Thank you so very much for your testimony, Mr. Hurst. I now wish to recognize Professor Barkow. I was recognized for 5 minutes.
Thank you, Madam Chair, Mr. Ranking Member, members of the subcommittee. I'm honored to testify before you today. So as you've heard, there are currently approximately 18,000 clemency petitions awaiting answers from President Biden. Almost 15,000 of those are commutation petitions seeking relief from excessive sentences being served right now, and another 3,000 petitions are requesting pardons. Unfortunately, clemency appears to be a low priority for the current administration. It inherited a backlog of 14,000 petitions, and instead of urgently addressing it, the backlog has grown by more than 28%. It's hard to overstate the level of mismanagement responsible for this unconscionable backlog. These people, many of whom have been waiting for years, deserve answers to their petitions, yet the administration has done nothing to suggest it has any grasp of the exigency of the situation. It hasn't changed any aspect of the clemency process that created this backlog. President Biden has granted just 78 clemency petitions so far, 3 pardons, 75 commutations, leaving 99.6% of the rest of the petitions in their holding pattern. It's not just the paltry number, but the nature of the grants that shows just how narrowly the administration is viewing this power. Most of the grantees were already released to home confinement under the CARES Act, but it's hard to see why only a few dozen people released under the CARES Act merited such relief instead of all of them as a categorical matter. The administration also noted that its recent grants included individuals who would be sentenced differently today under laws like the First Step Act that shorten sentences. But here, too, the administration granted only a handful of these cases out of the thousands just like them. If this were in any other area of government responsibility, there would be alarm bells ringing about the ineptitude of those in charge. Sadly, because clemency often fails to get the attention it deserves from the press and public officials, those calls haven't come as loudly as they should. But make no mistake, the failure to take drastic action to address the current backlog of clemency is presidential malpractice. So the question is what to do about it. In my written testimony and my prior testimony to you, I have urged Congress to use its legislative authority to create other second-look mechanisms, prevent excessive sentences from occurring in the first place, and create an expungement option. But Congress can also use its authority to improve the clemency process itself. Congress can't dictate how a president should exercise the constitutional power of clemency, but it can provide funding and incentives for needed institutional changes. The president currently relies on a process in the Office of the Pardon Attorney, as you've heard, and that is funded by Congress. Congress could instead fund a separate advisory board that exists outside the Department of Justice to provide advice to the president on clemency. Taking clemency out of the Department of Justice would address the bureaucratic duplication that Professor Osler described and that's responsible for much of the holdup in petition processing. It would also address the fundamental conflict of interest in having the same agency that prosecuted all those cases reviewing them for clemency, a structure that has resulted in egregiously low clemency grants in all recent presidential administrations. Congress can't require a president to use that board, but a designated funding stream for a clemency board would signal the broad support this idea has, and it would be more likely that it would be consulted, especially when a president like President Biden has already indicated his desire to do this as part of the Biden-Sanders Unity Task Force. While the proposal doesn't have to mirror the one in the Fixed Clemency Act, that is one option for making this change. Setting up a permanent board is, in my view, the preferred option, but a second best scenario would be to create at least a temporary board to deal with the clemency petition backlog. President Ford used a temporary board to address a large number of cases associated with evasion of the Vietnam draft, and that could be a model for this approach. A less effective strategy, but better than nothing, would be for Congress to increase dedicated funding for positions in the Office of the Pardon Attorney. 80 of these have been approved, but they have not been funded because of the continuing resolution. The reason this approach is less desirable is that it would address only delays from initial review in the Pardon Attorney's office, when a big reason for the backlog is the failure of the Deputy Attorney General and White House counsel's office to act. For example, we know that in fiscal year 2020, 63% of the pending petitions were waiting decisions by the DAG or White House counsel. They'd already been processed through the Pardon Attorney's office. So a board that's outside of DOJ would definitely be the preferred approach in my view, and I urge Congress to do that or take other measures to create replacement mechanisms for clemency. Thank you for allowing me to testify and share my thoughts. I'm happy to answer any questions you might have.
I thank the gentlelady for her testimony. And now I recognize Prosecuting Attorney Murray is recognized for 5 minutes.
Thank you. Good morning, Chairwoman Jackson Lee, Ranking Member Biggs, and members of the Judiciary Committee. My focus today is really, I want to take a pause, or I hope this committee will take a pause and think about public safety and the impact on local communities. My name is Morris Murray. I am the elected prosecuting attorney for Defiance County, Ohio. I first served as an assistant prosecutor back in 1985 before being elected to my current position in 2009. I'm a past member of the National District Attorneys Association board, and I'm also a past president of the Ohio Prosecuting Attorneys Association. I'm also proud to add that prior to beginning my law career, I served as a police officer for several years. I think it's important, and I'm compelled to note that today's testimony is being submitted on the heels of National Police Week, a time to recognize and salute our entire law enforcement community. I'd like to echo and support the comments of my colleague, former prosecutor Hurst. During my career, and I'm coming from the perspective of a local frontline prosecutor, I've prosecuted over 5,000 felony matters, all levels of severity. I've worked extensively for 30 years with a multi-jurisdictional narcotics task force. We are situated here in Northwest Ohio, and although our community is relatively small, we are in a situation where we often are the crossroads for drug trafficking and other serious offenses coming through and around our community from larger metropolitan areas. this is a dangerous, and I'm sorry to use the old cliche, but this is a slippery slope. And to the extent we allow this slope to continue in this direction, we are going to be compromising public safety. As this committee exercises its oversight role with respect to clemency and the pardon attorney, I'm compelled to express grave concern regarding the likelihood that increasing the number of offenders being released or anticipated to be released, we really need to take a serious and really non-political, apolitical look at the impact on public safety, on state and local law enforcement, and the available resources. Many of the offenders being released have committed very serious crimes. I certainly wouldn't dispute that there are some wonderful success stories that have been referred to in some of the earlier testimony, and anecdotally, those are there, and that's wonderful. The reality is there are already and likely to be substantially many more stories that are more tragic. The reality is that offenders involved in this level of serious drug offenses have been connected to the drug culture for a long time. And while we can talk about elderly prisoners or ill prisoners, the reality is we're going to see many 20, 30, 40-year-olds that are more likely to be granted clemency if we loosen up this process. This policy is coming at a time when we're seeing major spike in serious crimes, violent crimes, increasing and staggering numbers of drug-related deaths, coupled with an effort by some to redirect law enforcement resources away from what our first priority should be, and that is public safety. There is a common misconception that offenders convicted of federal drug laws, or any drug laws for that matter, are nonviolent offenders. The reality is this culture lends itself to violence. The business model itself is full of violence. Use of violence and intimidation is part of the business. We have a widespread distribution system throughout this country that's putting large amounts of drugs on the streets of all kinds, dangerous and deadly drugs. Some of these, even though small amounts may show up in communities like mine, they're coming through this distribution process. Offenders released that have been deeply involved in this process, common sense would suggest they're very likely to get back involved. Money drives this. Lots of cultural issues come into play. You're shifting the burden to local law enforcement and state authorities. Crimes will be enforced, drug laws will be enforced at the state level. And if you shift what the federal enforcement system can do and the holding of serious offenders accountable, you're going to shift that burden to local communities. I appreciate the opportunity to speak today. I come from a perspective of a frontline prosecutor, and public safety is our number one priority. Thank you.
Gentleman's time has expired. Thank you. Now I recognize Ms. Taifa for 5 minutes.
Thank you very much, Congresswoman Shirley Jackson-Lee, Chair Nadler, and members of this committee. Thank you for convening this important hearing. You have my comprehensive written testimony, so I will spend my 5 minutes focusing on 2 issues. First, the need to consider clemency for categories of people in general, shining a spotlight on that of quote unquote old law elderly prisoners, and second, the issue of posthumous pardons. If mass incarceration is ever to be abated, it is critical that intentional steps be implemented that expand the number of people eligible for relief. Individual commutations are not enough to tackle the enormity of this challenge. Thus, in addition to clemency petitions considered on a case-by-case basis, a categorical approach to releasing groups of deserving candidates for clemency must be seriously considered. At the beginning of this administration, the Justice Roundtable issued a report, Transformative Justice, and in it we outlined some categories that commutation could include, such as those who had unsuccessfully petitioned for compassionate release, elderly prisoners, those serving sentences that have since been deemed unjust but not made retroactive, Those serving excessively lengthy prison sentences as a result of exercising their constitutional right to go to trial, euphemistically known as the trial penalty. We stress that the sentences of people convicted of marijuana offenses must be commuted. Indeed, there's a robust campaign led by Weldon Angelos to that effect. We added that those who are COINTELPRO-era political prisoners who remain federally incarcerated should also be granted clemency, such as Dr. Mutulu Shakur, Veronza Bowers, Leonard Peltier. The report stressed that regardless of whether an individual fits into any of the categories suggested above, it is critical that the focus be on who the person is today and any post-conviction achievements they have attained as opposed to their conviction of record. The category I wish to highlight for clemency at this time is that of old law federal prisoners who were sentenced for offenses committed prior to November 1987 when federal parole was abolished and the U.S. sentencing guidelines went into effect. Grouped together, these people are referred to as old law prisoners, and they are among the very oldest and longest incarcerated in the federal system. Many are in the late 60s, 70s, even 80s. Many have underlying medical conditions. They pose no threat to public safety. Presidential clemency is their only recourse and their last resort. The U.S. Parole Commission engages in routine parole denials, and because of exclusion from the First Step Act, no one sentenced under the old law is eligible to turn to courts for compassionate release, unlike every other federal prisoner. Creating a rebuttable presumption for release for this category of incarcerated people will correct both the inaction of the U.S. Parole Commission as well as congressional oversight in omitting old law prisoners from First Step reforms. The second issue I'd like to briefly highlight is that of the posthumous pardon. While there is no question that pardons are most beneficial to those who are living, there are times when the granting of exceptional posthumous petitions are important and necessary to show that discredited values of the past are no longer the values of the present. There is precedent across party lines for posthumous pardons granted by the president. The four Bush, Clinton, and Trump administrations have each issued posthumous pardons, which I outlined in my written testimony. The quest for a posthumous pardon for early 20th century civil rights leader Marcus Garvey has been a multi-decade effort to right a wrong committed by the U.S. government nearly 100 years ago, and it has the support of millions. President Calvin Coolidge recognized the widespread abuses in his case in 1927, and he commuted his sentence. Despite this commutation, his name is still tarnished by the stigma of his conviction. His son, Dr. Garvey, and other son testified before this Judiciary Committee in 1987. Congressman Rangel, Congresswoman Yvette Clarke, and others have issued resolutions highlighting Garvey's accomplishments as a human rights leader and calling for his exoneration. So in conclusion, the president should use all of the tools in the toolbox with respect to clemency, and we thank this committee for examining all of these issues.
I thank you. Now, Ms. James, you're recognized for 5 minutes.
Good morning, and thank you, Madam Chair and Mr. Ranking Member. The National Council for Incarcerated and Formerly Incarcerated Women and Girls is the only national advocacy organization founded and led by incarcerated and formerly incarcerated women and girls. Organizing began in a federal prison yard with a group of women, including myself, who wanted policymakers instituting criminal justice reform to hear the voices of formerly incarcerated people, those who understand the harm the current system inflicts and have the expertise to create an alternative system that recognizes each person's humanity. As formerly incarcerated women, we believe a prison will never be the place to address the economic and psychological reasons women end up in prison. Prison most often causes further social and economic harm and does not increase public safety. The prison experience increases trauma in women, and if they are mothers to the children they are separated from. It deepens poverty in the individual lives of incarcerated people and the overall economic stability of their communities. Although our long-term goal is to end the incarceration of women and girls, we are also working to address conditions of confinement for those living inside of prisons. We support women seeking compassionate release and work to raise awareness of the horrific conditions in our prisons and jails. We support women seeking clemency. In the past several decades, clemency has become politicized. It is the notion that clemency is a gift is wrong. Clemency is an executive power that is enshrined in the Constitution. Justice Rehnquist called it the fail-safe of our legal system. It has been the foundation of justice since ancient times. The idea that granting clemency is being soft on crime is wrong. Clemency is based on an analysis of who the person is today, not what they did years or decades ago. People who have educated themselves, aged out of crime, are ill or elderly, do not need to be in prison. Their incarceration is not punitive, it is vindictive. Clemency is empathy in action. Anyone who claims to empathize with incarcerated people must support clemency for those who made decisions in difficult times and have grown and left their mistakes behind. Average Americans understand this. 62% of voters recognize that reducing prison populations would strengthen communities by reuniting families and saving taxpayer dollars that can be reinvested in communities. Clemency rebuilds families, fixing the harm caused by the Adoption and Safe Family Act. 2/3 of people in BOP custody have minor children. That means 65,600 mothers are in federal prison unable to raise their children. Put another way, that is 1.7 million children whose mothers are absent due to incarceration. The situation is, however, even more heartbreaking than that. Every 10th mother will never see their children again, even after they are released from prison. Approximately 11% of incarcerated women cannot leave their children with family members and thus end up in the foster care system. The Adoption and Safe Families Act of 1997 limits the amount of time any child may remain in foster care. Although creating a stable environment for children is desirable, AFSA requires states to terminate parental rights and place children in an adoptive family. This destroys the family of an incarcerated mother who could not place her children with a spouse or family member. Clemency also rebuilds families, fixing the harm caused by conspiracy laws. Conspiracy prosecutions are a major weapon of the war on drugs that disproportionately harm minor players, mainly women and people of color. The horror caused by conspiracy laws can be best illustrated by the tragedy of Michelle West, who is currently serving a 2 life plus 50-year sentence for a murder. My time is short. I do want to say that conspiracy laws are a toxic remnant of the failed war on drugs and must be reformed. The only way to fix this injustice is to reform conspiracy laws to bring them in compliance with basic principles of due process. Lastly, I do want to point out that there are several women who have come home, who are granted clemency, who have done a remarkable contribution to their communities. One of them is here with us today, Danielle Metz, who is our Director of Clemency at the National Council. Danny was sentenced to serve 3 life sentences plus 20 years in the federal system. Her sentence was commuted, and she is a remarkable contribution, an example of what happens when we grant women clemency. Thank you.
Gentlelady's time has expired. And I now recognize Mr. Hernandez for 5 minutes. Mr. Hernandez.
Good morning, members of the Congressional Subcommittee. I'm very deeply sorry I cannot be present today for this very important legislation addressing clemency reform. Thank you for allowing me this opportunity to speak on my behalf and those that are incarcerated. My name is Jason Hernandez, and I would like to briefly tell you who I was. I was a drug dealer, which I became at the age of 15. I was a defendant when at the age of 21, I was indicted by the federal government for distributing crack cocaine and sentenced to life without parole, plus an additional term of 320 years. I was a prisoner. In prison, I was a jailhouse attorney. 13 years into my sentence, I would write the most important letter and petition of my life. This letter and petition I sent to President Barack Obama on September the 21st, 2011, asking him to commute my sentence of life without parole. On December 19th, 2013, President Obama answered my prayers by commuting my sentence to 20 years. I would find out in 2018 from a New York Times reporter that President Obama received my letter and he read it. President Obama would go on to give clemency to 1,715 people, 500 who were serving life without parole. President Obama's show of good grace, mercy, and willingness to exercise his power to pardon so abundantly has been done by other presidents of the United States, typically in relationship to a war. President Abraham Lincoln would issue 64 pardons to Confederate soldiers for war-related offenses. President Andrew Johnson issued sweeping pardons to thousands of former Confederate officials and soldiers after the Civil War. President Jimmy Carter granted unconditional pardons to hundreds of thousands of men who evaded the draft during the Vietnam War. In 1971, the United States began a war which was called the War on Drugs. Since the commencement of the War on Drugs, millions of people have been arrested, charged, indicted, and sent to prison, a majority of which were Latinos or African Americans. I have stated above how the presidents of the United States have exercised the power to pardon people in some way committed an act related to a war initiated by the United States. Some of these wars were deemed controversial, some deemed necessary. The War on Drugs, controversial, necessary, could be arguments to support both sides. What we do know is that it was a war that was not thought out, misguided, ill-advised, racially biased, and has hurt Black and brown communities more than it has helped them. At a time when our communities needed sidewalks, roads, and better schools, we got more prisons. At a time when we needed mentors and teachers, we got more police. And acknowledging the war on drugs was a failure and should come to an end, one of the olive branches that should be extended is clemency. Former Supreme Court Justice Anthony Kennedy stated to the American Bar Association in 2003, a people confident in its laws and institutions should not be ashamed of mercy. I hope more lawyers involved in the pardon process will say, Mr. President, this young man hasn't served his full sentence, but he has served long enough. Give him what only you can give him. Give him another chance. Give him a priceless gift. Give him liberty. For still, the prisoner is a person. Still, he or she is part of the family of humankind. Earlier, I stated who I was. Now, since my release from prison in 2015, let me tell you who I am. I am a criminal justice reformer and the founder of Crack Open the Door and Get Clemency Now. I have contributed to nearly a dozen individuals being released early from prison, 9 of which were serving life without parole. I am an author who has written a book called Clemency Now, Get Clemency Now, which teaches people incarcerated and their families how to put together powerful clemency petitions. I am the 2017 Collin County Black Chamber of Commerce Trailblazer and Community Civic Leader of the Year. I am the 2018 McKinney Volunteer of the Year. I am the 2021 Leadership McKinney Alumnus of the Year. And I'm also the 2022 NACDL's Champion of Justice of the Year. I am also the founder and executive director of At Last, which is a leadership program for Latino high school students, which teaches them how to become leaders in their school and in their community. I was once inmate number 07031-078, and now through clemency and only clemency, I am once again Jason Hernandez. I hope and pray Congresswoman Ayanna Pressley's historic legislation to transform our nation's broken clemency system and addresses the growing problems of mass incarceration continues with the necessary steps so that it becomes law. There are more prisoners like me in there. There are more Kimber Smith Pradas in there. There are more Bill Underwoods, and there are more Sharanda Jones in there. And with this legislation, we can free them all. Thank you for this time, and God bless you all, and God bless this great country.
Thank you very much, Mr. Hernandez. Now, Mr. Underwood, you're recognized for 5 minutes.
I first want to thank Chairwoman Jackson Lee, Chairman Nadler, Ranking Member Biggs, and the members of this subcommittee for holding this hearing today, and for sharing this space to hear stories about the importance of second chances for people like me and families like mine. My name is William Underwood. I'm a 68-year-old senior fellow with the Sentencing Project's Campaign to End Life Imprisonment. Over 50 years ago, I was a teenage father in Harlem. I needed to provide for my family. There was one way to make fast money. I became involved in the drug trade to ensure that my son didn't know the hunger and pain I did. I previously testified to this committee about the impact of the war on drugs on me and my community and the racial injustice at its heart. I was ultimately sentenced to life without the possibility of parole and a concurrent 20-year sentence for leading a violent drug operation during the 1970s and early 80s. During my incarceration, I committed myself to growth and had no infractions in 33 years. I parented my children from behind bars, and they became steadfast advocates for my release. In the fall of 2014, President Obama announced the Clemency Initiative for people sentenced under mandatory sentencing laws. My clemency petition received support from entertainers, musicians, faith leaders, reformers, conservatives, sports figures, civil rights leaders, scholars, industry leaders, people I mentored in prison, and most of all, my children. President Obama ultimately commuted the sentences of 1,715 people convicted of federal drug crimes. I was not one of them. Instead, following the passage of the First Step Act, I was granted compassionate release in January 2021 at 67 years old. Judge Sidney H. Stein's release order cited letters from the men I mentored while in prison who said that I created a culture of responsibility among the men around me. Since my release, I've worked to create second chances for others. I was not an outlier in prison. There are many more people like me in federal prisons, and many who are older and sicker, yet who have been denied clemency and compassionate release. Clemency is valuable and should be available to all people who can safely return to the community, regardless of their crime or sentence. Clemency should also be granted far more frequently, but clemency should never be someone's only hope of freedom. There are three important ways that Congress could create more second chances today. First, Congress should pass the First Step Implementation Act and COVID-19 Safer Detention Act. The First Step Act reduced mandatory minimum sentences for drug offenses, but was not retroactive. The First Step Implementation Act would fix that inequity. Among other provisions, it would allow courts to give a second chance to individuals who have served at least 20 years for crimes they committed as minors. The COVID-19 Safer Detention Act would also help to reduce excessively lengthy sentences by expanding release opportunities for elderly or terminally ill individuals. It would give compassionate release eligibility to people sentenced before November 1st, 1987. The bill also includes urgent provisions to protect the lives of elderly individuals by adding COVID-19 vulnerability as a basis for compassionate release and shortens the judicial review process for early release during the pandemic. Second, Congress should transfer jurisdiction of old law individuals to federal courts so that they can receive a meaningful opportunity at parole. People sentenced in federal courts before 1987 are entitled to parole hearings every 2 years. People age out of crime, and old law individuals are elderly and have a low risk of recidivism, but few people receive parole. In 2021, the U.S. Parole Commission granted parole to less than 20% of old law individuals who received hearings despite the health emergency in federal prisons. We believe federal courts are better equipped to fairly judge whether these individuals deserve parole. Finally, Congress should pass legislation to allow everyone sentenced to be reassessed after 10 years. 10 years is long enough to see how someone has grown and changed and to reevaluate whether they should go home. That's why in 2019, Senator Booker and Representative Bass introduced the Second Look Act, which would give all people in the federal prison system a chance to have their sentence reviewed after 10 years. Receiving a second chance shouldn't be an extraordinary event. If we believe in redemption and the rule of law and acknowledge that our criminal justice system has been biased or too harsh, it should be routine. My story should not be rare. I urge you to consider all the men and women like me. Please remember their dignity, their worth, their loved ones, and their vulnerability as they grow old behind bars, and give them a path home. Thank you.
Thank you very much, Mr. Underwood, for your testimony. And thank you for all of your statements, for your opening statements, and for your contribution to this hearing. We'll now proceed under the 5-minute rule with questions. Now begin by recognizing myself for 5 minutes. It is important to realize how many people we have incarcerated and the desire for them to start anew or to contribute to society. So Osler, help us understand the impact of soliciting the local prosecutors and giving that considerable weight for someone who's been incarcerated and has a whole new attitude and change of life? Can you explain that conflict of interest and how other clemency process models would prevent that conflict?
Yes, thank you for that important question. And one thing that I want to make clear is that I don't think anyone is talking about cutting DOJ completely out of the process where they would not have a voice. It is important that DOJ has voice and people who know what the core imperatives are there. However, I will say this about going back to the local prosecutors, that I was an assistant United States attorney, and there's something that prosecutors know, and that is that there's a deep moral commitment to your work. And that is a good thing, because when I'm asking for a sentence to someone like Mr. Hernandez, I'm standing 20 feet away from someone and saying that I want that person to miss their child's wedding, to not be there when their mother dies.
Osler, my time is short. I have other questions.
Well,
I'm
I
so
will
sorry.
say, sorry. Okay, just that there is a deep commitment that that person has, and it's tied to the moment of the crime. And it doesn't take into account how people change over time. These petitions often are 20, 30, 40 years later. And that deep commitment is tied to a different point in time, doesn't account for the change in the person's life, including some of the changes that we heard about from some of the other witnesses here.
Thank you. Professor Barkow, tell me why you support the creation of a task force, a board or commission very briefly. I do have other witnesses that I want to question. Thank you.
I'm in favor of the creation of an advisory body that exists outside the Department of Justice. One, because it'll help alleviate that duplication of effort and get rid of some of the bureaucracy. Two, because it won't have the same conflict of interest, and the people appointed by the president could have relevant expertise in the kinds of questions that come up with clemency and evaluating how that person is today. And three, because I think when you have a specialist body like that, it can be more efficient and get petitions processed more quickly, and they can be a good resource for the president. I should say, I don't think any of this replaces the president's authority. I agree that it is 100% within the president's prerogative to grant or deny, but what it would do is provide the president with better sources of information and an efficient process, as opposed to what the president is getting now, which is effectively nothing, which is a backlog of 18,000 people. They're not getting a yes, they're not getting a no, they're not even getting a maybe. They are just sitting in some kind of a purgatory, and creating an advisory board would help cut that red tape, get rid of the conflict, and give the president better advice.
Thank you so very much. Ms. James, I think we started out by hearing thoughts that all we might be doing is adding to the criminal element, and that we might be creating danger. And I do want to pay tribute to our law enforcement during Police Week. We all want to be safe. But you made a very important point that I know, as I've been working with incarcerated women. Many of them are there for conspiracy charges that impact women who are grabbed into the system and given enormous thing. And they, of course, that completely implodes in many cases, as do fathers, the family. Would you comment on that, and that releasing these women would be a contribution to society, not a detriment?
Thank
Ms.
you.
James?
Thank you. Thank you. I would like to comment on that. I am a former criminal defense attorney. I stood in countless courtrooms defending women, men, children. I'm also a formerly incarcerated woman that served a sentence inside of a federal prison. Madam Chair, but for conspiracy in the federal prison system, the majority of the women who are currently incarcerated in our federal prisons could not justify the prosecution, indictment, and sentencing at the lengthy sentences that these women received. Conspiracy is something that we must take a very deep look at. We have been doing a years-long research study with incarcerated women in the federal system. It causes egregious harm, disparately impacts women, particularly women with children, separating them for unconscionable periods of time for sentences that otherwise could not be justified.
Gentleladies, time has expired, and my time has expired. Thank you very much. Now, my privilege to yield to the ranking member, Mr. Biggs, for 5 minutes.
Thank you, Madam Chair. And again, thanks to the witnesses for being here for some very enlightening and informative testimony. I want to go back to my opening comments and try to address them with how I see this, how I see it now. Professor Osler, I appreciate the diagram that you put up there, and Professor Barco, I read your statement, and I find it very interesting as well. But I wanna we have a real short amount of time, so I'm gonna keep you on a short leash. But I do want your responses to this, because when you talked about this, both of you. And I wrote down next to yours, Ms. Barco, I wrote, creating a system outside the system. I get it. This is the system as it currently sits. This is the system. It grew organically. The president controls this system, is my point. And I think we all agree to that. And so my question is if you create a system outside the system, which is kind of what we're talking about, are you not just sticking another box on that board? And that's would be my concern if you really want to streamline this. Are you just, and I'll go to you first, Ms. Barco.
There's no guarantee that that's not the case. I concede that, because you can't force the president to use it. If you create an additional body. I think, though, that it wouldn't work out that way because, one, this president has claimed that he wants to create a body outside of the Department of Justice. He just hasn't done it. And two, I think Congress creating something like this gives it an imprimatur that Congress thinks it's a good idea. And the idea would be having that agency set up, and I would think of it more like an advisory board, would kind of sell itself because the president would find it to be useful. But there's no guarantee, and you could find that the president decides, I don't want to use that, I want to stick with this, or I'm going to take that and funnel it.
I hate to cut you, but go to Professor Osler real quick.
Yeah, we would hope that the president would not make that bad choice. And I'd point something out, too, that the president doesn't pick everybody in this chart. That certainly picks the DAG, and sometimes is happy with that choice and sometimes not. But the staff...
But the rubric.
Well, and that's...
He could change that rubric today. And he's approved only 78 clemencies. We've seen, after President Obama left, you had 13,000 in the pipeline. You had 14,000 after Trump. You've got 18,000 today. Any president... And I'm not saying either party or the other, they're the ones that actually could change the systemic, because I think, Mr. Osler, you're describing what I would say is maybe a potentially systemic problem here. And if it's a systemic problem, the Constitution gives one individual the authority to actually clean up that process. And we may send a signal from the Congress, we may not, and I would suggest that those signals have probably been sent for multiple administrations. So how do you avoid just putting another box on there? And I'm going to give you about 10 seconds because I have to get some other questions answered.
Yeah, well, I just want to note that when the president sets a rubric and says, I want these people out, this system has done terribly. For example, most recently, we had President Biden saying, I want people from the CARES Act. You got a handful.
I get it, yeah. I mean, I think there's probably everybody sitting at this table and through at the room to say the rubric might have some real issues, okay? So I thank you for that. And I wanted to get to you, Mr. Murray. What role do the actual victims of violent crime, because we have about 8% of everybody that's in federal prison is requesting clemency. So what role does a victim of violent crime have in this current rubric, or should have in clemency decisions?
Is that question addressed to me?
Yes.
I'm sorry, I couldn't hear that part of it.
Yeah.
My perception is that that's a very minimal role, and the other difficulty there is how you define victim. Talked to a mother whose 20-year-old son just died of an overdose drug that was trafficked to that 20-year-old. That mother's a victim. There's a lot of variety on that question. I don't believe there's significant input. I keep hearing the term bias from the side of prosecutors, but a number of the panelists and a number of the people involved in the process come from the defense side, from the offender's side, and where do we balance potential bias?
I hate to cut you off because I appreciate it, but I wanted to get to Mr. Hurst. You've experienced this on both sides, defending and prosecuting. Where does the victim fit in this process?
The victim should fit into this process. I mean, this is the whole point of law enforcement, to keep us safe and to prevent people from becoming victims. And so, yes, victims should have a role in this process, just as they have a role when we prosecute federal crimes. We have a victim witness coordinator in every U.S. Attorney's office in the nation, and we consult with victims when we prosecute cases.
Thank you. My time's expired. Thank you, Madam Chair. And thanks.
Thank you. Thank you very much. I now recognize the chairman of the full committee, Mr. Nadler, for 5 minutes.
Thank you, Madam Chair. Professor Osler, because the federal system lacks expungement opportunities for individuals, the only relief they can get from the collateral consequences of conviction is through the clemency process. Can you explain how the lack of access to clemency, along with the burden of a criminal conviction, prevents successful reentry and reintegration?
Yes, I can. And part of the reason I can is because I run a clinic at my school where we represent people for pardons. We know what it means to them. And every case is going to be different, of course. But for example, it may seem mundane, but there are pardon petitions from people where what they want to do is go hunting with their grandchild. But they can't, because they can't possess a gun. And that may be a little thing to some people, but it's a big thing to that grandfather. There's people who can't get a license to do the job that they want to do. And perhaps most importantly, many people just want to feel whole again. They want to feel that they have moved past, that it's recognized that they are no longer the person that committed that crime. And that's what pardons can do. And unfortunately, this system serves commutations poorly. It serves pardons even worse. Thank you.
Why do you say that it serves pardons even worse?
Well, for the last, during the Obama presidency, during the Biden presidency, there's been an emphasis on commutations. And because the bandwidth is so thin from the pardon attorney on up, when they're focusing on commutations, pardons get shunted aside.
Thank you. Professor Barco, in your testimony, you discussed the possibility of removing the clemency process entirely from the Department of Justice. Can you explain how that would help address the bureaucratic barriers and increase relief for individuals seeking clemency?
Sure. It would effectively get rid of that chart. And so you would have a body that replaces it, provides all the information to the president, and then the president still makes the ultimate decision. And the president could tell that advisory body how it wants to run. It could say, look, these are the cases I want to prioritize. This is the way I want you to look at petitions. I want you to favor this category or this kind of person. But what you would effectively have is a dedicated board that is supposed to just do clemency. What you have in that chart is you have one office that does that, which is the Office of the Pardon Attorney, which is woefully understaffed. And then it has to go through these other two places in the chart where the White House counsel and the Deputy Attorney General, they just are prioritizing other things, and not unreasonably so. And so placing an advisory board that is just designed for clemency gives you the benefit of specialization and efficiency. It takes away any kind of bias that exists from having the same agency that brought the case make the final decision. You still get input from the Department of Justice. You still ask about facts of the case from prosecutors, but you have it be evaluated by an objective party that doesn't tilt on one side or the other, is just trying to think what is the best outcome and advice to give the president.
Thank you. Ms. Taifa, in your testimony, you discussed the need for clemency to fix past wrongs that led to mass incarceration, such as mandatory minimums and other harsh sentencing. How can improving the clemency process address the ongoing racial disparities in the criminal justice system and make the system more equitable and fair?
In my testimony is through categorical clemencies, looking at groups of people. Because mass incarceration has been so massive, the solution to it needs to be massive as well. There is precedent for it. We have talked about the Ford clemencies for Vietnam-era draft resistors that happened also with respect to Carter, and it was very effectual, and there was no danger to public safety or anything along those lines, but it sought to correct issues and help to heal the nation, because that was a very controversial time. Mass incarceration is controversial.
But excuse me, but that was a categorical clemency to an entire class of people. You're not talking about that.
Well, actually, I am. I'm talking about various classes of people, one of which I spoke of was the class of old law prisoners who were sentenced before 1987, before the Sentencing guidelines went into effect. They don't have any recourse, and clemency is basically their only avenue that they have for release. They have no benefit from the First Step Act compassionate release processes, and the parole board has been basically ineffectual.
Thank you very much. My time has expired. I yield back.
I thank the chairman. I now recognize Mr. Gomer for 5 minutes.
Thank you, Madam Chair. Appreciate all the witnesses' input today. I heard Dan Lundgren, a member of Congress, shortly after I got here, when the discussion in this committee was about the gross unfairness of having so much more severe sentences for crack cocaine as compared to powder cocaine. And we were told that that was racist to even have that. And Dan Lundgren had been here when that was passed, and he pointed out, and I went back and pulled some articles and found out he was right, that when the extraordinarily higher punishment for crack cocaine was passed through this committee in the House, there were members of the Congressional Black Caucus, including Charlie Rangel, that said, if you vote against this, then you're in favor of destroying the black community, that this crack cocaine is just a poison to the community, and we have got to have these more severe sentences. And so it was passed. You had a committee, you had all kinds of research, but for those of us that have been sentencing judges for felonies, most of us didn't see any reason for that kind of big disparity in sentencing. So a new committee, a better research committee, doesn't necessarily mean that we're going to have a solution to the problem. One of the concerns I have about blanket across the board decisions on sentencing after the fact is that most of the judges I know, I was a state felony judge, but federal judges as well have these massive pre-sentence reports, and some of us spend a tremendous amount of time agonizing over all the details in that pre-sentence report and trying to come to the right conclusion. And then to have somebody, some committee, some body come in and say, we don't know anything about this case, but we're going to come in and adjust that sentence. Well, they may not know what the judge knows from the pre-sentence report, that actually there was a gun involved, but in order to get someone to testify against a bigger guy, there was an agreement, we won't include the gun charge, so you'll get a lighter sentence. I mean, these are things that are considered at the trial court that don't get considered when this body comes in and says, we're going to have a blanket adjustment to sentencing. And there's been a good deal of criticism of President Trump for granting pardons in the military system. And I would encourage others on this committee, please join with me in helping reform the military justice system, because when you have the same commanding general that signs an order saying, I want this person prosecuted, and even without saying it, it's clear to every commander, everybody below the commanding general, that he wants him convicted or he wouldn't have signed the charge. And then the general gets to pick the people that will be on the jury, and the jury doesn't even have to be unanimous. It's a problem. And we have had a lot of unfairness in the military system. And I know that's not what anybody here is about. But when we're taking a look at unfairness in justice, that is a grave unfairness. And actually, President Trump didn't get everybody that should have gotten a pardon. One of the finest hires I've ever made was somebody that was treated that way in the military justice system. And he now works for me. He didn't get a pardon, but he's a brilliant guy, and he's going to help us make these changes. But I just point those things out from somebody that has agonized over sentencing and tried to do the right thing in sentencing. It's not fair to have somebody come in that doesn't know the case you did and change the sentence, but we have got to work toward more fairness. I appreciate it. I appreciate it. Yield back.
Gentleman's time has expired. I now recognize the gentlelady from Pennsylvania, Ms. Scanlon, for 5 minutes.
Thank you, Chairwoman Jackson Lee, for holding this hearing today, and to all of our witnesses for being here. Executive clemency can be an important tool in our justice system. However, as so many have attested today, the current process could use some work. I had the privilege to participate in the Clemency Project 2014, an effort led jointly by the then White House, the Department of Justice, and a host of groups across the ideological spectrum to grant relief to nonviolent offenders who'd been subjected to mandatory minimum sentences, which we've since moved away from. In that project, we trained hundreds of private bar lawyers across the country and joined them in screening thousands of case files and filing hundreds of clemency petitions on behalf of individuals who met a rigorous criteria for consideration. And I was really pleased that the team at my law firm obtained clemency for 29 individuals. And I think their stories can help inform this conversation and dispel some of the rhetoric and fears about releasing dangerous individuals into the community. One of them was Michelle Miles, who was jointly represented by my former law firm and NYU students under the supervision of Professor Barco. Another was Cindy Shank, whose story was the basis for an award-winning 2018 documentary, The Sentence, which provides an in-depth look on the incredible impact that clemency can have. But I also know that thousands of clemency applications were left unaddressed when President Obama left office, with his successor choosing to prioritize clemency and pardons for his personal associates and individuals recommended by social media influencers using no discernible objective criteria other than political expediency. So I understand that our current process can be burdensome, inefficient, and both underutilized and subject to abuse. So it sounds like there are ways we can improve the clemency process and ensure that the president can effectively implement this important tool. So Professor Barco, yesterday I joined Congresswoman Presley and two of our Republican colleagues, Representatives Joyce and Armstrong, in a letter to the pardon attorney requesting disaggregated demographic data on the clemency application backlog so that we can better understand its impact on communities. We know there are currently over 17,000 pending clemency petitions stuck in that backlog. Can you give us a sense of who the applicants caught in the backlog are? And do many of them meet the criteria for clemency established by the last couple administrations?
So I'll answer that to the best that I can, but it's not a very transparent process, which is one of the problems, is we don't really know because the pardon attorney doesn't give very much information about what the petitions look like. But what I can tell you is there are thousands of people who would not be serving the sentences they're serving today because the law itself has changed, and Congress did not make the changes retroactive, for example, in the First Step Act. Other than making crack cocaine changes retroactive, all the other changes to mandatory minimums are just forward-looking only. So there's a lot of people who are serving sentences that wouldn't get the sentences they have today. Similarly, they wouldn't have gotten the sentences they have today because they were sentenced under mandatory guidelines and they didn't get covered by the Obama initiative. So we know there's thousands. I can't give you a precise amount. I can tell you the Sentencing Commission did a report after the Obama initiative and found that there were thousands of people who met his criteria who just kind of escaped review under that process. The other thing we know is there's thousands, I don't know the precise number, I've tried to get it from BOP, this committee could get it, who have been released under the CARES Act. So they're already released under home confinement. Attorney General Bill Barr released them, but they will go back to prison if the pandemic is declared over, if the emergency is over, unless they get clemency relief. They were a big chunk of the people who got the grants from President Biden in those 75. So that's another large group of people that's in there. And then we have a lot of people who are serving sentences under mandatory minimums. To go back to Representative Gohmert's point, those judges had no authority to give that sentence. Their hands were tied. And many of those judges would very much like to see those people get clemency because they actually weren't the product of a judge looking at individual circumstances and facts. They were mandatory minimums that the prosecutor brought, and they were triggered by the conviction or the plea. That's it. You know, the judge couldn't do anything about it. So those are some of the people that are in that pool. They have families, they have loved ones, they've served their time, they have reformed. Many of them, like Mr. Underwood, have, you know, unblemished records that are very hard to have while someone is incarcerated, and they're just looking for a chance to get a second chance and show that they're no threat to public safety.
Well, I share your concerns that the White House and DOJ lack the resources to tackle the backlog and be more efficient moving forward, and that there's a potential for conflict of interest within the DOJ. Can you just speak very briefly about how the Pardon Advisory Board could assist with that?
The gentlelady's time has expired.
Okay, Madam Chair, I just would request unanimous consent to enter into the record an article from Nation of Second Chances detailing the experience of Michelle Miles, who received clemency from President Obama in 2016.
Without objection, so ordered, and the gentlelady witness can provide the answer in writing. Thank you for your courtesy.
Thank you.
Thank you very much. I recognize now Mr. Tiffany for 5 minutes.
Thank you, Madam Chair, and it's good to have all of you here. Mr. Underwood, it's good to see you here before this body once again. You cited President Ford, I believe, Ms. Barco, in that that he set up this panel. I mean, isn't it the case that the president can do this if he wants to?
Yes, I've urged him to do this, and he has not yet.
And isn't it the case that he could just reprioritize? I mean, we hear about this backlog. Can't he reprioritize this within his Department of Justice and say, we want to see more of these reviewed and the decisions expedited?
He can. That's a little bit trickier, to be honest. President Obama effectively tried to do that. He told the Department of Justice what he was interested in doing. It's very hard to get that machinery to crank out what the president wants, because you can see it's a bit of a bureaucratic mess. And it's hard to oversee that in a way that gets exactly what you want out of it. Yes, the president can do it. I would say the best thing he could do is to give the Department of Justice very clear categories, as Ms. Taifa pointed out, and that's the most effective way to get this organization.
I'm so glad that you bring up the bureaucracy, because we're going to comment on that later. That's one of the great concerns I have, having served in state government. Are we setting up a parallel bureaucracy that ends up just being a problem? I hope I say your name correctly, Ms. Taifa. You were talking about a categorical clemency or commutation or whatever. So do you believe we should have a broad class of people that should simply be given clemency? Or
What I'm talking about is a rebuttable presumption of release for specific targeted categories of persons. And there, I gave examples of a number of different categories, but it's not just a broad get out of jail free type of situation. It's a rebuttable presumption, meaning there will be a presumption, say if someone has served a certain amount of time, has complied with all the things they're supposed to comply with in prison, that they should be able to be granted release, a presumption of that. That could be rebutted by the prosecutor or whatever, but there should be some type of process that can be expedited, and that's one way of going about that.
Thank you for your answer in regards to that. I am also, I think we also have to really be mindful of victims in regards to this. I think about in the state of Wisconsin, our Governor Evers, who named his parole commission, just recently was going to parole someone who had a heinous record of a brutal murder, and the family was outraged that the parole commission that was named by Governor Evers, that they were going to let this person loose. And so I think we have to be very mindful of the victims also. Mr. Hurst, how often in the, let's say the last decade, does someone go to prison for simply a simple marijuana possession charge?
Oh, I have no idea. I don't know. I don't have that in front of me.
Mr. Murray, can you answer that question? How often does somebody go to prison for a simple marijuana charge? Simple possession.
Sure. Almost never at this point in time. Only large quantities. Obviously, with the trend across the country as it relates to cannabis, there's less and less emphasis. Resources aren't available. We're inundated with meth and other more serious drugs, and the attitude is that we don't have the time or the resource to deal with marijuana.
So what you're saying,
very rare.
Mr. Murray, is it's pretty rare to see that. It's rare to see that happen.
Mr. Tiffany, I can tell you in 15 years as a federal prosecutor, 0 have been prosecuted in the Southern District of Mississippi for simple marijuana possession.
Yeah, okay. Just follow up, Mr. Hurst. What are the unintended consequences of, you've got 20 seconds to answer this. What are the unintended consequences of making this change?
Well, I think the unintended consequences is what Professor Barkhouse said, which is the president can just ignore it. And the problem is we're just creating more bureaucracy. If you look at the Fixed Clemency Act, we're putting more people on the federal dole, we're funding more retirements, we're funding more salaries, we're basically sending the taxpayers' dollars out for no apparent reason.
So thank you for that. And I'm just going to close with this. I am so glad you all brought this up in regards to the bureaucracy, because we see it everywhere in the federal government. It happens everywhere. When you hear us talking about natural resources, you hear us talking about any issues where there's huge impediments in the way. You see charts like that you could double the number of people that are in the way. That happens all over our federal government. We need to fix it, and I'm so glad you bring it up, and I'm glad you bring up negative decision bias that goes on in our federal government. I yield back.
Gentleman's expired. Now pleased to yield to the gentlelady from Missouri, Congresswoman Bush, our Vice Chair, for 5 minutes.
St. Louis, and I thank you, Chairwoman Lee, for convening today's crucial hearing. And thank you for your partnership and collaboration on such an urgent issue as clemency, which has been a top priority for me since I was sworn into office. 3 weeks ago, after months of urging from myself and our fellow colleagues, President Biden granted clemency to 78 people, including 75 commutations and 3 pardons. I was absolutely proud to see two of those people were residents of St. Louis. In exercising this extraordinary executive authority, the president cited redemption and rehabilitation as core values of our nation. I couldn't agree more, and I commend him for taking this necessary step. During the previous administration, the president largely used his clemency power for cronies, for family members, political allies, and friends. Rather than a tool of redemption and decarceration, he wielded this authority for nepotism and corruption. Clemency became an extension of the privilege afforded to the rich and the powerful. In the context of our punitive carceral system, clemency provides President Biden with the authority to put humanity over greed, justice over violence, and righteousness over corruption. Ms. James, in your testimony that 65,600 mothers are in federal prison unable to raise their children, leaving 1.7 million children behind, and that every 10th mother will never see their children again, even after they are released from prison, how would mass commutations and clemencies impact Black and brown communities, particularly women?
Thank you. And thank you for your support for our efforts around clemency for women in the federal system, Congresswoman. Clemency allows the president to strengthen communities with a stroke of a pen. We have thousands of women currently incarcerated who have lots of years inside already, where their children were infants and now maybe 10, 11, 12 years old. That is typical throughout the federal system. We have women like Danielle Metz, who's here with me, Congresswoman, who you have met and personally had conversations with. Danny's story is unfortunately not an anomaly. It is so common in the federal system. And Danny is here with us today, thank goodness, after 23 years in a federal prison where her children grew up without her. And the Adoption Safe Families Act, which we have to desperately work on, is something that destroys families because it requires that the state remove custody of parents. And it did not take into consideration the fact that many of these people were going to be incarcerated women. 85% of currently incarcerated women are mothers, and they were the primary caretakers of their children prior to their incarceration. We must do something to recognize the further harm and trauma that happens when you separate mothers from children and that you remove these women from our communities. And clemency is gender justice. It is an opportunity for us to correct some of the things that all of the people on this panel, including conspiracy and other things that have led to significant convictions in unreasonable amounts of time that are affecting the women in the federal system. Women just like Daniel Mitz, just like Virginia Douglas, just like Kemba Smith, women just like Amy Pova, women just like Michelle West, going on her 29th year of incarceration, never an infraction during incarceration, whose daughter Mikkel has come before this committee and the White House countless times to beg for a second chance for her mother. And so this does mean something to us. Clemency would provide a huge tool to help us to move these women and help to reunite and heal families.
Thank you.
Thank you.
Thank you. Ms. Taifa, you talked powerfully about Marcus Garvey's conviction being unjust, but outright wrong. Why is it so important to exonerate Garvey and other leaders of racial justice who have been victims of prosecution?
Thank you, Congresswoman. It is so very important because there have been so many instances of injustice in this country, not just what's happening now, but what has happened historically. And Marcus Garvey served to unite Black people, not only in this country, but across the world as well. And he was targeted by this government. He was targeted by the predecessor to the Federal Bureau of Investigation, the Bureau of Investigation under a young J. Edgar Hoover. And the trial was amidst of issues dealing with race and dealing with politics. And even the president at that time, Calvin Coolidge, agreed and as a result commuted that sentence. But that commutation did not remove the stigma of his name. And his living son, Dr. Julius Garvey, has been seeking to restore the honor of his father, his image. Marcus Garvey's image is on the currency of the nation of Jamaica. All over the world, people have been honoring him. Dr. Martin Luther King, Nelson Mandela, others, many leaders around the world have learned from his teachings. Thank you.
Thank you, I yield back.
Thank you. Finlay's time has expired. Thank you very much. Let me acknowledge if there are any other members that are in the room.
Madam Chair, Mr. Massey is in the room and would like to speak.
I'm delighted to yield 5 minutes to Mr. Massey.
Thank you, Madam Chairwoman. There's no doubt in my mind that we have thousands of people in this country who are incarcerated unfairly or over-incarcerated. They've served their time, they've been punished enough, and that they should be released to lead productive lives. With that said, clemency is a tool of the executive branch, not of Congress. And I think we need to take this opportunity to think about what we could do in Congress to fix these problems or to prevent these problems. I don't think mass clemency is the answer any more than mandatory minimums is the answer to crime, because it's a one-size-fits-all. But I do think there should be more clemency and more considerations given on an individual basis. Ms. James, you mentioned conspiracy and how so many people are charged with conspiracy. Just to summarize for those people who are watching this is a way to prosecute somebody who's not committed a crime. What we have to do is have the resolve in Congress not to pass more conspiracy laws, but we're doing it every year. But it's not easy to vote against some of these bills that have the conspiracy stuff stuck in them. The anti-lynching bill had a conspiracy charge or clause in there so that you could convict somebody who'd never been involved in lynching somebody of lynching somebody merely for talking about it. And so it takes resolve on the part of my colleagues to vote against these things where we create new conspiracies. Also, mandatory minimums. These are one of the most dangerous things that we've created here in Congress. And they're a creation of Congress, not the executive branch. We don't let the judges have the discretion that they should have to determine what the actual punishment is to fit the actual crime. But when you've got a bill, and it's a bill to prevent sex trafficking, and there's a mandatory minimum in there, it's hard politically. It's hard for my colleagues to vote against a sex trafficking bill, that would cut back on sex trafficking, even if it's got a mandatory minimum in there. But they're not considering the fact that that mandatory minimum could be used to prosecute a receptionist at an internet hosting company merely because that internet site was used for sex trafficking, and the single mom who's the receptionist there, maybe she knows something's up and it's not, everything at this company's not on the up and up, but she's got to feed her kids and she's working there as a receptionist. Why does she deserve 10 years in prison when the person who's actually committing the crime may get exactly the same sentence? It just takes a lot of resolve. We got to start reading the bills, read the bills, look for these things in there, and offer amendments to take out the conspiracy charges and to take out the mandatory minimums that are in there that tie the judge's hands, and then create this problem on the back end where you need to use clemency. And I'd just like to use my remaining time to talk about one case of Ross Albrecht. He was a young, peaceful, first-time offender serving a double life prison plus 40 years. The guy has been condemned to rot in prison for setting up a website called Silk Road. And there were people selling drugs on there, and he probably knew that was happening. But the people who were selling drugs on there who got convicted are already out of prison. And the guy who set up the website when he was 26 years old is now 10 years later. This fall, it will be the 10th anniversary of his time in prison. He was an Eagle Scout. He doesn't claim that he was innocent. He knows now that it was a crime. He's asking for clemency. He's asking for his sentence to be commuted. And, he's got a college degree. He could be a productive member of society. And so I would like, hopefully, the executive branch to look at this case. But, Madam Chairwoman, I would like to submit for the record a summary of Ross Albrecht's case from freeross.org and remind people that Ross was never prosecuted for causing harm or bodily injury, and no victim was named at his trial. I ask unanimous consent to submit these 2 pages from that site.
Without objection, so ordered.
Thank you, and I yield back the balance of my time.
Gentleman yields back. Mr. Biggs, do you have, I do have some concluding remarks. Mr. Biggs, you have concluding remarks. I yield to you at this time.
Madam Chair, thank you. I'm going to forego my concluding remarks because of the vote. Thank you, Madam Chair. Thank you to the witnesses.
Thank you as well to the witnesses. And let me again, I do have some concluding remarks. Let me thank Congresswoman Presley, Marc Osler, Professor Osler, Professor Barkow, Professor at one time, but a CEO and founder of the Taifa Group, named Kichi Taifa, Andrea James, Michael Hurst, and the Honorable Morris Murray. In concluding, let me say that the genesis of this hearing was absolute necessity, and the thousands that languish in prison in our federal system that really warrant this response of a clemency or a pardon. I think what the witnesses have generated today is that there is bipartisan support for a response and for an answer. And so as I conclude, I just want to briefly submit into the record the story of Anthony Todd Robinson, who was an Army officer who was arrested on mistaken identity for sexual assault and spent 27 years in the state system in Texas. He received from then Governor Bush clemency, and he is also now a board certified law graduate and attorney helping those who are particularly in need. That is Mr. Robinson. And so in addition, Michelle Miles, Israel Torres, Waylon Wilson are all individuals released under this system. They have not contributed to crime. They've contributed to society's best, and they have made an economic contribution to our engine of our economy. We must recognize that there are different times when people were incarcerated and arrested, convicted, and from the time that they come and seek clemency. Very quickly, Mr. Hernandez, you tell a powerful story. And can you just quickly say why you're seeking a pardon?
The reason I'm seeking a pardon is to make me whole again, to give me a chance to be back, as you could say, my civil rights, whether that's to hold public office or to rent an apartment, to get a certification or a license in the state of Texas.
You are a person today than you were before. Is that correct?
Excuse me, ma'am, what was that?
You're a different person today than you were at the time of your criminal activity.
Oh, yes. Even when I wrote President Obama, I told him I wasn't in a position to tell him I deserved life or freedom. But what I could tell him was that I was a changed person, but that I wasn't that 18-year-old kid that sold drugs over 15 years ago.
All right, thank you. Let me quickly go to Mr. Underwood. Can you explain how clemency can be used to right the wrongs of a tough on crime era? That was an era of really lack of options. No one thought creatively. Yes, drugs were horrible, and I defend those people who at that time felt that was the way to go, but there were no options. And then it lasted forever. Mr. Underwood?
Yes, ma'am. Well, one thing that could do, since a look at resentencing, could look at a person and see that they're not the person they were. They can determine, you know, look at resentencing is not a get out of jail free card. A look at resentencing is for a district court judge after thorough vetting of the individual, and look at them and see that they're not who they were when they came in many years ago, and that they're a reformed person and that they can contribute to society as an American citizen.
Thank you. Ms. Taifa, on the issue of Marcus Garvey, let me just add to the point very quickly, the time is running, that many persons fighting social ills were caught up in the criminal justice system. Marcus Garvey, that happened to him, and he deserves the respect of a response of a pardon. Is that your view? Ms. Taifa?
I say absolutely, yes, he definitely deserves a pardon. We need closure to that era in history.
Thank you so very much. Again, I want to thank all the witnesses. The guiding post is that we must do something to reform the clemency and pardon process. This oversight hearing was not a first step. I believe it should be a comprehensive step. We do need to meet with the pardon attorney, with insist that we do so, and as well, we need to begin to reform this process immediately, for there are too many good mothers and fathers and people who are seeking to do better in this nation. With that, again, my appreciation to all of the members who participated. This concludes today's hearing. Thank you to our distinguished witnesses for attending. Without objection, all members will have 5 legislative days to submit additional written questions for the witnesses or additional materials for the record. And now this hearing is adjourned. Thank you to the witnesses.